Lawyers, what was the dumbest thing that won or lost you a case? Before we start, don't forget to subscribe to the channel so you don't miss the next videos. I wish you a pleasant viewing experience. Story 1. Not my story, but one I heard as a young lawyer, illustrating the dangers of asking too many questions on cross-examination. The lesson being to quit while ahead. Don't ask open-ended questions that allow the witness a chance to explain. The case was about a vicious fight outside a bar. The accused was accused of biting the victim's nose off. The only witness was an elderly fellow who saw the whole thing. On direct, the witness said he saw the two fighting in a whole crowd of brawlers from across the street at night. The defense cross went something like this. Q. I see you are wearing glasses here in court. Are you nearsighted? A. Yes. Q. From the police report, it says you were not wearing your glasses that night. I. Yes, I ran out of my house without them when I heard the riot. Q. Again, from the police report, it was particularly dark and foggy that night. There was only a single light above the bar, and you were 100 feet away. Is that correct? A. Yes. Q. So you admit you are nearsighted, that the visibility conditions were not good. You could not possibly have been able to see exactly what happened 100 feet away from you, correct? A. Well, yes, but Q. Please just answer the question. A. Yes, sir, and here the lawyer ought to have sat down. Instead, they opened their mouth and asked the fatal question. Q. So given you admit you could not have seen exactly what happened, why did you testify it was my client who bit off the victim's nose? It could have been any one of those fighting A, because later, your client ran right past me and spat a severed nose onto my shoe. The latter bit had not been in the police report and was not mentioned on direct. Answer. Vinnie Gambini. Mrs. Riley, when you saw the defendants, were you wearing your glasses? Constance Riley. Yes, I was. Vinnie Gambini. Pointing upward and Mrs. Riley not looking in his direction. Over here, dear. Would you mind putting your glasses on for us, please? Vinnie Gambini. Stumbling a bit from staring into Mrs. Riley's eyes through her very thick glasses. Whoa! How long you been wearing glasses? Constance Riley. Since I was 6. Vinnie Gambini. Have they always been that thick? Constance Riley. Oh no, they've gotten thicker over the years. Vinnie Gambini. So, as your eyes have gotten more and more out of whack, as you've gotten older, how many different levels of thickness have you gone through? Constance Riley. Oh, I don't know. Over 60 years, maybe 10 times. Vinnie Gambini. Maybe you're ready for a thicker set. Constance Riley. Oh no, I think they're okay. Vinnie Gambini. Maybe we should make sure. Let's check it out. Vinnie Gambini, grabbing a tape measure from his desk and bringing it over to Mrs. Riley. Now, how far away were the defendants from you when you saw them enter in the sack of suds? Constance Riley, about 100 feet. Vinnie Gambini. 100 feet. Vinnie Gambini, handing Mrs. Riley the end of the tape measure. Would you mind holding this, please? Thank you. Vinnie Gambini, making his way through the crowd to the courtroom door. Sorry, excuse me. Sorry. Okay, this is 50 feet. That's half the distance. Vinnie holds up 2 fingers on his right hand. Vinnie Gambini. How many fingers am I holding up? Mrs. Riley is squinting, trying to see the fingers. Judge Chamberlain Haller. Let the record know that the counselor is holding up 2 fingers. Vinnie Gambini. Annoyed. Your Honor, please, huh? Judge Chamberlain. Haller. Oh, sorry. Vinnie Gambini. Now, Mrs. Riley and only Mrs. Riley, Judge Chamberlain gives Vinnie a dirty look. Vinnie holds up 2 fingers on his right hand again. Vinnie Gambini. How many fingers am I holding up now? Constance Riley, squinting, trying to see the fingers. 4. Vinnie Gambini. Coming back to Mrs. Riley amid the courtroom rumbling in she getting the number wrong. What do you think now, dear? Constance Riley. Thinking of getting thicker glasses. Story 2. I had a client when I was working in the clinic at law school. She had stolen pills from a hospital, and the DA sent me security camera footage. It was legit her like 10 FT from a camera, looking around and shoveling pills in her pocket. I asked my professor how to approach it, and he suggests showing her the video. I did that, and her response was, so do you think I have a case? She ended up magically finding money for a non-public defender and fired me. She ended up getting a few years in jail. Answer. When I was in APD, this always baffled me. People would come in with the most clear-cut evidence against them. The only thing you could do was negotiate a plea deal that was as favorable as possible to them. They would then hire a private attorney and spend hundreds of dollars for what I could get them for free. The worst was this one time. Guy comes in on a suspended license charge. Super minor and easy to deal with. I told the client this wasn't a case to fight because he can't win and he goes out and hires a private attorney. The next time he shows up to court with said attorney, his new attorney literally asked me what the prosecutor wanted in terms of a plea, and I handed her the plea form I had filled out at the previous court appearance. She literally just has this dude sign the form I had already filled out, and they enter the plea. His private attorney probably did 15 minutes of work total on the case max. This dude could have saved himself a couple $100, but decided he didn't trust my opinion at the time. Things like that happen dozens of times. There were even a few times where my former client got a worse deal after getting a private attorney because they didn't trust a public defender. Story 3. I had a fairly simple assault trial. Facts are a pretty basic homeless guy was told to leave by security and was ushered away. Homeless guy got upset and hit the security guard. We have some cell phone footage that shows this, but ultimately the key moment wasn't clear, and it could have been argued that the security guard touched him first. Defense counsel asked the defendant a few questions, then goes in front of the jury and asks him to essentially position her how the security guard was and reenact what happened. They more or less agree that she should be standing about arm's length away and pointing, like a typical, "Hey, you can go exist there, but this is private property" kind of thing. She then asks, "And what did you do?" My dude looks right at her and slugs her right in the mouth. Not even a gentle reenactment tap, but fully committed to trying to knock her out. Her lip is bleeding, and she looks shocked, like she was fully unprepared for it before sitting down. Skeleton, any cross? Just briefly. Sir, just to confirm, you hit the security guard just like that? Yes. Up until that time, did the security guard ever touch you? No further judge. I didn't even get out of the courthouse parking lot before I got called back for the verdict. Story 4. Public defender in first felony trial, meth trafficking, where they had the whole exchange caught on video, including my client's alleged face and his license plate as the exchange took place in his car. When arrested the next day, he still had the marked bills in his wallet. All I could argue was reasonable doubt. Probably isn't enough. He was facing 20 years because of his record. After 10 minutes out, the jury came back and asked if they could see my client's teeth. On the video, he had a bad case of meth mouth, but he had not testified, so the jury didn't get a chance to look in his mouth in person. The judge said, "Sorry, the proof was closed." They came back not guilty 5 minutes later. Spoke to foreman after. He said they were pretty certain it was him, but his teeth were so distinctive, they wanted to see them to be absolutely certain. I asked, "What about the license plate and marked bills?" His brow furrowed. That actually didn't come up back there, but yeah, I guess it was definitely him. Should we tell the judge? It's too late. It's over. Answer, kinda similar. Friend was on a jury for a case where guy got arrested for allegedly selling substances at a park. Guy's defense was no, he was there to play basketball, and the cops planted the substances. A few other in the jury wanted to vote not guilty based on that being possible. My friend had to remind them that it was nighttime and dark, no lights in the park. Guy was by himself and was not in the possession of a basketball. Story 5. Not a lawyer, but I do technical work for lawyers. I'm going to generalize this excessively because it's a real case. Did some data recovery analysis of a dash cam from a company vehicle involved in a very serious accident. Driver claimed to not be at fault. After doing recovery on the SD card from the camera, I found a video of a company manager sitting at the wheel in the company garage weeks after the accident, while the vehicle was supposed to be quarantined as evidence. He was on the phone with someone receiving instructions to do stuff to the dash cam. We could hear him say, "No, I already pushed it." He had pushed the red record incident manually button and recorded himself tampering with evidence. Presented in pretrial negotiations. Case settled immediately in favor of my client. Answer, this wasn't a court case, but sort of similar. At a company I used to work at, I was part of our incident review team. Anytime there was any sort of accident with any of our company vehicles, we reviewed the drive cam footage. One of our technicians had hit a low-hanging tree branch. No one was hurt, but it did significant damage to the service van. He swore the branch must have fallen as he was driving by because he never saw it until he heard it hitting the van. We sit down to watch the video. He is texting, eating a hot dog, and looks straight ahead and yells, "Oh shoot, a tree." I'm not sure why he felt the need to lie. It was near impossible to get fired at this company. He wasn't fired for this, just written up and had to take a safe driving class. Story 6. Do administrative proceedings count for this question? Years ago, I was working for a partner doing municipal and planning law matters. He had a client, a Hindu group, originally from South India, but established here in Canada, who wanted to build a community center. They were being blocked by a municipality in the flimsiest grounds. The correspondence, back then, all on paper, It's that long ago, being unbelievably rude and dismissive of our client. Naturally, the client assumed the municipality planning office was full on racists. How else to explain their bizarre behavior? Mind you, and this is important, they had never actually met for an in-person meeting. This was all by correspondence. At the first meeting with the client, they were fighting mad. They wanted to launch a proceeding right away, had in fact already filed the paperwork before they realized they needed professional help, which would have earned our firm tens or even hundreds of thousands of dollars in fees. I was given the task of summarizing and categorizing the correspondence for the partner, and a single glance at the correspondence, Brad told me what the problem was and how to solve it right away, and sadly lose our firm those hundreds of thousands in fees. The group was called something like the Vedic Aryan Society. Their decorative letterhead had an ornamental border of swastikas. It was obvious from the correspondence that the city planners had literally no idea who Vedic Aryans were, or that they were originally from South India. They were acting under the assumption these guys were neo-Nazis because of the use of the word Aryan and the decorative swastikas. Just as the clients assumed the planners were vicious racists, so too did the planners assume that the clients were vicious racists. Hence, turning down the application on flimsy grounds, the nasty tone in the correspondence, which virtually said, "We don't want your kind in our community," etc. A single letter carefully explaining this was basically all it took. The application was approved, the proceeding withdrawn, plus some free advice, which was that a different choice of decorative border would avoid such issues in the future, and hence the dumbest possible waste of time was avoided. Answer: I just read in another thread about people have problems naming babies. A lady was complaining that her husband, who is Indian, wants to name their kid Aryan, which is a Sanskrit word that means noble. She is trying to talk him out of it because they live, and their kid will grow up in America where that has very negative connotations to it. He has final say because they made a bet. If they have a girl, she gets to pick the name, no questions asked, and vice versa. He is refusing to budge. Story 7. Heard this one from a friend defending a client charged with beating a man to passing with a bat. Cops found him shortly after, a block away from the crime scene, holding a bat and wearing a coat both covered in the victim's blood. He argued at trial that he was walking down the street, minding his own business, when another man offered him a free coat if he would hold his bat for a few minutes. He said he accepted the bat and put the coat on. He then proceeded to wait for the mysterious man to return when the cops found him. Jury was not out long before returning a guilty verdict. Story 8. My uncle went to watch my dad, a defense lawyer, in court on 2 occasions. Both times my uncle was identified by a witness as the suspect, dismissed and dismissed. Answer: twice I was the primary witness in minor criminal cases, and I was asked if I could ID the suspect in a crowded outer room hallway before we even entered the actual courtroom. Both times I was able to quickly do so. In both instances, I was told by the prosecuting attorney that if I had not been able to correctly ID the suspect in that pre-trial setting, they would not have proceeded. So not at all like the movies with a witness in the stand dramatically pointing to someone seated in the courtroom gallery. Story 9. This wasn't a trial, nor am I a lawyer, but at one point I was interning for a family law attorney. He had this one divorce case he was in the middle of, and I sat in on client meetings and mediation with the other party. They were discussing custody and weren't able to come to an agreement, so I propose a potential agreement to our client. And after the other attorney talks it over with their client, they accept. After we leave the client, I'm riding high on the thrill of resolving things, when the lawyer I was interning with told me that the custody schedule I proposed was identical to one that had come up earlier in negotiation. The only reason they accepted this time is because both parties perceived me as a sort of neutral third party, so they believed the compromise was more fair then when it had been proposed by one of them. Story 10. This is more funny than anything. I'm a contract attorney in the entertainment and sports world. Had a client who's a mid-level writer-director calls me one day and says, "Hey, what legally constitutes a contract?" I explained the basics that there has to be an offer of terms, acceptance of terms, consideration of value, mutual agreement, capacity to make the agreement, and the offer in question has to be legal. I hear silence and then a shit. We may have an issue. Goes on to explain that he was in Vegas for the week and got to talking to this guy. They are having fun, getting goofy, and the guy pitches him a story. He loves it, and long story short, he writes it on paper the bartender had. That on the date, he agrees if he uses this idea, the guy either gets 25 profit or a part in the idea, his choice. He signed it. The guy signed it, and the bartender witnessed it. I laugh. He says, "But I love the idea. I've legit spent the night writing it out. How fudge am I?" I asked him who took the signed paper. The guy did. Were you tipsy? Stone cold sober. Was the guy tipsy? He never saw him drink. I said risk factor is low but possible. He is a bit upset. Asking if he can change it, the story, and get away with it, etc. I said that was a question for his copyright attorney. Offhand, I asked where he was, when, and if he knew what the bartender looked like. He gave me all that. He was going to ask his copyright lawyer as he has a good start on the idea. Few days later, I was able to track down the guy working the bar at the place he was at. Guy calls me back, explain who I am, and ask him if he by any chance remembers a scenario I laid out. He starts laughing. He finally responds, "Yeah, I remember those two. They were blitzed out of their minds. They were doing bumps at my bar. That's why I came over. Then they wrote up that shoot and asked me to sign it. I did. But we had to ask them to get the fudge out when the guy pulled out a pipe. I asked if he happened to know what happened to the paper they signed. He said, I threw that shoot away. It was all gibberish and illegible anyway. I just pretended to sign it with a straw because it was the only way they leave. But hey, I will say your guy left me a 75 tip. I hung up and texted my client back that I had taken care of it, and his response was praying, hands in 3K cover your time. Dude got an option with his idea he and his bar buddy cooked up, but never got produced. Story 11. Not dumb, but definitely not anticipated. I was representing a kid who was about to turn 18 and lose his Social Security benefits because while he met the requirements as a minor, he did not meet the cognitive requirements as an adult. He was too smart. Our argument was that, while his cognitive test showed he had progressed, he was still unable to hold down any sort of employment due to diagnosed PTSD stemming from persistent harassment at school and a violent incident where he had been mugged on school property. I had reviewed our argument and had planned on his mother providing significant testimony. We had gone through the traumatic scenario a few times, and he was able to describe it without problem. Because of this, I was comfortable having him testify on his own behalf in court. However, when it came time for him to recount the scenario in court before the administrative law judge, he totally broke down. He was basically inconsolable and utterly incomprehensible. We never ended up getting to his mother's testimony. I thought I had tanked his case and felt horrible for putting him in that situation. They ended up prevailing, though, largely because he demonstrated that upon even being reminded of that situation, he was not able to maintain any sort of composure and needed such support that his prospects of finding and maintaining employment were zero. Answer: I have done that. I have cerebral palsy. I have a low-paying retail job because that is all I can do. I was an adult destitute child, and my father was required to pay support past 18. My father was a narcissist who sued to end support because I could do a job, not if I could support, have a house, and more. My mom was served with papers on Mother's Day morning. I was ready to testify. I am smart enough, but learning issues and more put me in a position to fail if appropriate support is not provided. But I had to recount multiple times where I had failed because it was just my limitations. My learning issues and more that set me to fail. Recounted it enough that I just broke down and cried. No one ever wants to have reality crush that hard. Also that someone has no empathy. My mom won the case and I still got support from my father. I never saw or spoke to him again. You know why. Story 12. Interning for a public defender. Statutory violation case. 30-year-old defendant accused of having intimacy with a teenager. Gross, but everyone's entitled to a fair trial. Paralegal gave me a recording of a phone call from the jail where the defendant was being held. Asked me to transcribe it. Apparently, the prosecution has just entered it into evidence. I listened to the phone call. It's the defendant calling the teenager he'd been accused of having intimacy with from jail to tell her how much he couldn't wait to have intimacy with her once he got out of jail. He explicitly admitted to the accusations and made it clear it hadn't been a one-off, but rather a repeat occurrence, something that had up to that point been in contention. Turned into a quick plea deal. Answer: don't be shocked if you stick in criminal work that this is common. I had a domestic violence case where we were going to the last call before trial, and I had just gotten jailhouse tapes the night before. I didn't have time to go through the multiple hours before the hearing, so had to rely on a quick skim, but it was clearly going to be 2 CDs, maybe 3 worth. I tell the court this, and the defense immediately tries to jump down my throat, withholding evidence and such, but the judge and I were both cool, so I asked the PD which one they'd prefer to be the first exhibit. The CD titled Babe. Babe, I love you, babe. Please, I love you. Or the one starting, mocking crying noises, please. It is so hard in here. I mean, I'm fine either way. I haven't heard the entire thing, but probation, can you confirm that the defendant has a no contact order with the probation nodding victim? Story 13. I had a client charged with illegally camping on public land, aka being homeless in public. I moved for a dismissal at first appearance based on lack of probable cause. The municipal code defined camping as sleeping outdoors between 9 p.m. and 7 a.m. I pointed out that the police citation showed that they ticketed my client at 8:30 p.m. Story 14. It was a class action data breach case. We were suing a company who had accidentally emailed out thousands of their customers' info to a group of scammers. Ridiculous negligence, complete disregard of even the most bare-bones data protection scheme. Bunch of arrogant, rich assholes. Now, due to some procedural weirdness, we had to prove that our class representative specifically had monetary damages as a result of the data breach, which would normally be a huge problem because actual provable damages as a result of a data breach are extremely rare. But we had a class representative who was pretty unusual. He had gotten the boilerplate notice of data breach and had absolutely freaked out about it. Panic attacks, medical problems, lost his job. So in a 1 in a million situation, we had an opportunity to actually hold these people accountable for damaging the whole class of tens of thousands of people. The defendants got our representative's employee file in discovery and found he had been fired for a third strike of missing work. He had been home with a panic attack, but they wanted to show that he had skipped work for his daughter's school field trip, which had actually been a second strike. So we showed up to a hearing with an elementary school field trip schedule, which allowed us to recover millions of dollars for the class. Story 15. In IL. I was told this story a long time ago. Local PD had been working undercover as homeless people and were targeting muggers in the city center. The defendant was in court with a cast on his leg and crutches nearby. He'd been shot by the arresting officer. The officer was on the stand giving the details of the arrest, and it went something like this. I was working undercover on the mugging task force, dressed as a homeless person. The defendant produced a knife and demanded my wallet. I gave him the wallet and he fled on foot. I gave chase, identifying myself as a police officer and ordering him to halt. The defendant continued to flee, and after multiple warnings, I drew my revolver, took careful aim, and disabled him, which allowed me to effect the arrest. The defendant jumped up and yelled, "Your Honor, that policeman's a liar." After I took his wallet, all I heard was, "Guess who?" Bang! No idea what the outcome was. Story 16. In oil, but on jury duty, a father and son got into a physical argument, both adults. Son pressed charges for simple assault. There was plenty of evidence to acquit as it sounded like mutual combat. Son was kind of a shithead and was egging him on, pushing, etc. up until the punch that busted his lip and led to the cops being called. We were ready to acquit up until the dad took the stand. Virtually the first thing out of his mouth, "Oh yeah, I whooped his jerk good." With plenty of detail, his lawyer and judge both visibly shook their heads, had to convict. Story 17. I was involved in an entirely normal paternity case where a woman had a baby and filed for paternity. The guy disputed it and said he wasn't the father as usual, and the court ordered the standard paternity test. The test results said he wasn't the father of the baby, but surprisingly, it also excluded the mother. After a lot of discussion, we kind of heard off the record that the mother probably borrowed someone else's baby in order to make a child support claim, and didn't understand that when a court orders a DNA test, they usually test the mother against the baby as well. Story 18. Not a lawyer, but one of my employees' stories. He went out on disability for a sore back, happened a lot in the union come springtime. Guys would say they're going to visit Dr. Summeroff. He was also an urchin diver, and when the company sent someone around to make sure the guy wasn't scamming the system, they took photos and videos of him going in and coming out of the water in full scuba gear. Took the guy to court, and his defense was that they couldn't prove it wasn't his twin brother. Case dismissed, guy came back to work in the fall. Answer. There was a famous burglary in a department store in Berlin in 2009 where jewelry and watches valued $2 million were stolen. Police found DNA traces that were already on file for well-known criminals, which could therefore be quickly apprehended. Problem. There was only a single trace in a glove, matching the DNA of twin brothers. Since there was no other evidence, they ultimately could not be convicted because it was impossible to say which of the two brothers left the trace. They had to let them go. Most of the stolen valuables never resurfaced. State attorney tried again 10 years later with more modern technology, but again they had to give up. Story 19. Tia 1. Saw a lawyer argue a case as follows. Judge, how does your client plead? Lawyer, not guilty, Your Honor. Judge, on what grounds? Lawyer, the description of the suspect in the police report mentions the suspect having one leg, Your Honor. Judge, ruffling through papers. Yes, I see that written here. Lawyer, well, my client has two legs, Your Honor. Judge visibly baffled. Case dismissed. Edit. To answer some people's questions, this was not during a trial like those on TV. This occurred in a lower-level court, think the court that handles parking tickets and public intoxication charges, where the stakes were lower and most people didn't have attorneys. As a result, a lot of the usual court formalities were disposed to make things easier and more efficient. I am aware that in a formal trial this would never happen, but here I doubt more discovery was done beyond reading the police report. Answer, also not a lawyer, but I do landscaping for a defense attorney who's still practicing into his 70s, and he shares some of his better stories with me. He had a client who was a contractor and was driving in from a neighboring state with an employee after finishing a big job. Apparently they were huge tweakers, and to celebrate a job well done, had purchased a substantial amount of methamphetamine. They got pulled over, and while the owner didn't exactly look or act like a meth head, the employee who was driving did. The cops call the substances dog, and it alerts. They get busted and charged with a couple felonies. Anyway, the client is retelling the story and is insistent that there was no substances dog. The lawyer shows him in the report when the dog came, etc. The client then says, no, the substances dog cops were there, but there was no dog. He ended up reviewing the dash cam footage from the canine handler officer, and sure as shoot, when they go to get the substances dog, he just reaches into his back seat, grabs a leash, and then walks a leash around, then makes a barking sound as the alert. He said it was the craziest thing he'd ever seen from a police officer in all his years. Both cases ended up getting dropped entirely. Story 20. I was on a jury once for a road rage incident. The guy was driving a truck and forced a young girl in a car to hit a barrier wall. The defense attorney tried to paint the girl as an addict and was very belittling to her on the stand. It made us sympathetic to her and not the other way around. There were also witnesses that all basically said the same thing. The guy was at fault. The only thing we didn't find him guilty of was the damage to the vehicle because the prosecutor never brought or showed proof of the damages to the car, just that it was totaled. Story 21. Lady worked for a missile factory making missiles for the Air Force. Had a bogus bodily injury claim off a fender bender. Was treating with some questionable medical practices that get paid out of the proceeds of the lawsuit, so we were already suspicious. Come to find out, her treatment records show her being treated when she is logged into the Secure Access Missile Facility, monitored by the U.S. government contractor. On cross, I showed her both sets of records and asked her to pick which ones were more likely to be true. The missile factory with the secure facility or the medical practice trying to get paid out of her lawsuit. She picked missile factory. She wound up losing and owing my client $230,000 in legal fees, which her plaintiff's law firm had to partially cover. They don't put that possibility on the billboards, y'all. Story 22. Not me, but a lawyer told me when a witness testified that her client was wearing a mask during an armed robbery. He shouted across the court, she's lying. I wasn't even wearing a mask on that job. Answer, that came up during the Nuremberg trials too. One of the Nazi war criminals testified you couldn't remember anything from that period of his life due to some sort of brain damage. So they had a witness start making accusations of things that never happened, and the defendant stood up and declared that that never happened, which proved he had a memory of it. Story 23. I'm not an attorney, was a pre-law student before switching to engineering my junior year. Now I have master in planning and a MLS in land use and environmental law, so I'm familiar, but was sued for getting rear-ended. Yeah, you read that correctly. I braked suddenly to avoid a deer, and a guy rear-ended me. The guy had recently had a spinal fusion in his neck, and his airbag messed up the hardware. So he figured it was his shot for a payday. As soon as the responding officer showed up, and the guy who hit me flashed his badge, I knew I was not going to get fair treatment. I didn't. The responding officer did not write him a single ticket, but wrote me a ticket for reckless driving and coming to a sudden stop without adequate signal. My insurance company offered to settle with him for $20K, but he wasn't having it. So off to a deposition I went. The deposition went well, I thought, and my insurance company made another offer of $60K. Again, his ambulance chaser lawyer plastered on billboards all over said no and said their offer was $500K. A court date was set. It was going to be a bench trial, as that's how my state handled some of these. I managed to easily get both tickets dismissed pro se and thought that was that and he'd finally settle. Nope, homeboy pressed on. My attorney was provided by the insurance company, and I had since moved away, so they flew me back and forth for the deposition and the court date. So in court, my attorney called the responding officer to the stand and asked one question. It went like this. Lawyer, were the brake lights on the defendant's vehicle operational? Officer, yes, they were. Lawyer, that is all, Your Honor. The The plaintiff's attorney got up to speak and the judge stopped him immediately and said, "No, stop right there. Don't waste your breath. This matter is dismissed with prejudice." My trial lasted all of 15 minutes. The dude could have gotten a $60K settlement from my insurance company, but instead got nothing and had to pay his attorney. A shady cop either slipping up or choosing to be honest on the stand might have saved my jerk. Even better, since he lost and never took the settlement offers, my insurance rates never went up. My insurance company said they'd be going after him to recover their expenses. I assume they did. Story 24. Well, I'm not a lawyer, but my BIL got away with a DUI. Crashed his mom's truck into a fence along the side of the road. Got out and started puking on the side of the road. Owners of the fence heard it, then saw what was happening and called the cops. Cops show up and arrest him for DUI, but don't read him his rights. They also never saw him driving, nor did the witnesses. So his lawyer argued there was no proof he was the driver, and his testimony to doing so was thrown out, according to him, because he was never read his Miranda rights. Whole thing got thrown out to his fortune. Unfortunately for him, he picked up another DUI charge that stuck while going through the legal process of the fifth one. He was not given mercy on his sentencing. Answer: one little quirk that is hard for people to understand is that the police only need to read your read rights before they question. If they don't intend to question you and don't question you, they never have to read you your rights. When I was a PD, had client who felt so strongly he was going to skate on a very serious felony because the police didn't read him his rights. Was a big letdown for him to finally believe me when he learned it was irrelevant because the police never questioned him. The cops knew he was represented by counsel, so they didn't bother. He was a repeat offender, so it wasn't anyone's first time. Story 25. Client facing a termination of parental rights case calls me the day of the trial to tell me she can't make it to court because her current boyfriend surprised her with tickets to the Caribbean. Actually told me to call her after the trial to let her know how it went. Spoiler alert, it did not go well. Story 26. My buddy's employer lost a fairly significant case involving injury on a construction site because their lawyers just didn't show up. Story 27. Not a lawyer, but my brother is. Typically, jurors don't get to know whether or not the defendant has a criminal record because it could skew the case. However, during jury selection, the judge often asks the jurors themselves if they have any criminal records. If yes, they wouldn't be selected to be a juror. Well, during jury selection, the judge asked the room to raise their hand if they had a criminal record or criminal experience. My brother's client raised his hand. After the trial was over, guilty, the jurors asked my brother to tell the guy that they thought he was the most honest witness of all the witnesses in the case. Story 28. Client was accused of fraud, was so scared of being caught on the first fraud that they forged another email to disprove the fraud. The second email made it a stronger case. Story 29. Company wasn't doing great, so VC plaintiff sues the entrepreneur saying that defendant hadn't revealed key information risks. This was not long after Theranos, so presumably he thought he would play that game as the misled investor. There was a lot of evidence that these risks had been disclosed, but the real cherry on top was that in meeting minutes that the VC himself had edited for clarity, it showed that they had discussed this key risk and he invested after that discussion. Seems he hadn't disclosed that to his attorney. Story 30. One of my first public defender cases, I was representing the sweetest, tiny little 410 lady for a felony criminal destruction of property case. Typical it wasn't me excuses, but as a noob I fully believed her. We stood on business and at the pretrial conference with the prosecutor, I told him we were taking this one to trial. He laughed. I should have known. On the way out the door, he says to me, "Oh, I almost forgot. Do you want the video? I have it here and can just transfer it to you on a USB and avoid discovery." While looking at my client, I asked the prosecutor, "Video?" We watched it together. My client was wearing the same dress she wore to court. We did not go to trial. I got her 7 months in county and a downgrade to misdemeanor. She only did 3. She found out she was pregnant and got an early release. She was an awesome person who made an emotional mistake. I truly hope she's doing better. In FWIW. I never noticed her name in the client pool again, unlike several of my repeat customers. Story 31. Okay, this isn't a time I won a case, rather got a client to hire me. A potential client called for estate planning help and wanted to speak directly to me because he had never hired an attorney before, and he wanted to ask a couple questions, scope the vibe, etc. He was forthcoming and let me know he planned to shop around before choosing an attorney. So we are chatting briefly and the conversation starts to go like this. Him. I was wondering if there's a way with a will to achieve XYZ goals. Me. Him. Well, I'm sure there's a way to do it. But are you able to do that? Me. Where there's a will, there's a way. Finger guns in my office by myself. Him. Okay, I'll hire you. Who knew a joke that dumb would do the trick? My kind of client. Edited for formatting. Story 32. No one noticed that the date stamp on our expert's video of the fire scene did not match the date he said he was there investigating. Story 33. I've always loved the case of the man accused of stealing a Miami Dolphins jersey wearing it to court. Video. Story 34. I don't have a really great one of my own yet, so we'll share one of my bosses. We repped an event company that was putting on a hot air balloon show on behalf of a city that had gotten out of the case on sovereign immunity grounds. The plaintiff was a volunteer who had signed up through the city's program, so hadn't signed a waiver with our company and wasn't supposed to be helping with the hot air balloon stuff at all. The volunteers were supposed to be doing things like setting up booths and putting out chairs. Anyway, plaintiff came over to the balloon area, asked if they needed any help, and was told sure, he can help hold one of the ropes while the balloon is being raised, something to do with it needing to be loose while being raised, and then they could tie it down after. Not entirely sure of the specifics on that. It wasn't a main issue. Plaintiff was told to put on some gloves, but he didn't, and to absolutely not wrap the rope around his hand. He did. Surprise, surprise. The balloon jerked and ripped the skin off a part of his hand. Ultimately, he only had about $6,000 in medical bills because it wasn't that serious. Didn't lose a finger or tear a tendon or anything, just the skin. Now, 95 of personal injury cases in my jurisdiction are valued essentially by just taking the meds and doing a multiplier of like 1.5 to 3 for pain and suffering, with practically all of them settling in that kind of range. Given the nature of the injury, though, we were on the higher end. So the value range we had on it was 3 to 5x or 18K, 30K. Now that's an expected jury verdict range, so settlement offers tend to be lower earlier on since they'd save time and expenses against actually taking it to trial. We offered 12K before trial, got rejected. They were at 250K still. Probably could have gotten our client up to 20K or so if they'd actually tried negotiating, but they didn't. Anyway, at trial, they're playing it up as the worst injury imaginable and that he's traumatized for life and can't deal with his ugly scarred hand. After quite a long back and forth between plaintiff and his attorney, as plaintiff describes how disfigured the hand is and how he wears a glove all the time now so people don't have to see it, plaintiff's counsel kind of does a dramatic pause, turns toward the jury and goes, "Well, show it to him." So plaintiff takes off the glove, sticks out his hand toward the jury, and the whole jury leans in, squints, looks at plaintiff's counsel, back to the hand, and then kind of lean back with all sorts of looks of confusion on their faces, because there was barely even a scar. Verdict was the medical bills only down to the penny. The thing is, the initial photos were pretty gruesome, as you'd expect when a person is missing skin from half their hand, with blood everywhere. Those were in evidence, and the jury definitely reacted to them at the time. But by playing up the long-term, lifelong emotional distress from the totally permanently disfigured hand, he basically lost all sympathy. If it had been me, it'd have had him admit that everything's okay now, and he's grateful for that. But he deserves to be compensated for having to go through the ordeal and the obviously immense pain he felt during the recovery. But oh well. Story 35. Of course, I'm not a lawyer, but we took our former landlord to small claims court. When we moved out into our recently purchased house a few days before our term was up, then the day we emptied the apartment, the landlord came in and cleaned while we still had a few days left on the rental. The plan was to go back and clean it up before the lease was up. However, a day before the lease was up, we got a statement from the landlord keeping all our security deposit for them to clean the apartment. Now, the last day of our lease, the apartment has been cleaned. By the landlord, we didn't have to do it. Now, since they had cleaned it prior to the end of our lease, when we vacated, it was clean. We were going to argue when the lease was up. Based on the landlord cleaning already, it was clean, and we didn't have to pay for it to be clean. So in small claims court, before we even got to argue it was clean at the end of our lease, the judge reviewed the contract, and there is no provision for the landlord to charge for cleaning. We won, but not for the reason we expected. We got it money. I did learn, however, that with small claims court, there really isn't any provision to enforce the fine. If they didn't pay, you were effectively required to take them to the regular court and get a judgment and some mechanism for them to pay, like putting a lien on the property. Even though the amounts for small claims court have increased over the years, you don't hear of many cases taken to small claims court. If you don't think this is true, this is from the Illinois Small Claims Court website, Judgment and Enforcement. If a judgment is issued in your favor, The court can order the losing party to pay the debt, but you may need to take further steps to enforce the judgment if the other party doesn't comply. Answer: I had a somewhat similar experience, though it didn't go very far. My former landlord had changed the locks before the end of our tenancy period, found this out when I went to clean the place, then started a whole bunch of repairs before the final walkthrough. So the walkthrough was a bunch of, this was damaged, so we had to replace it, coincidentally with upgraded stuff throughout. Then the landlord sent me a final bill for repairs that totaled $8K with my $1K deposit applied. The supporting documentation was a bunch of estimate paperwork, crucially, not receipts, just estimates. The piece de resistance was the estimate to have the driveway resealed because my car had leaked coolant, and the estimate was for 2 driveways. I looked over the paperwork, laughed, and promptly ignored it. 6 months later, right around the time annual income taxes start being filed, I get a threatening letter from former LL that if I don't immediately pay this outstanding balance, it may have to go to court. Former LL doesn't know that both my parents were landlords and that I knew 90 of what she claimed was illegal for her to charge, and I had pictures of the place when we had finished moving our stuff out. So I had my lawyer draft a "bring it on" letter. She lost her shoot, ran down to my lawyer's office and screamed at his receptionist for an hour. Lawyer was in court that day, then called the next day and screamed at my lawyer for half an hour, which I got charged for. Totally worth it because she dropped the whole thing after that. Story 36. I'm not a lawyer, but the person that had his driver's license revoked and then appeared in the trial using a video call where not only he was obviously driving, but also mentioned it like it was obvious before he realized how fudge up he was. That precisely case must be a top dumbest things a man pulled out in a trial, in a situation that certainly made the lawyer to get away as soon as possible from the court. Here's the link. Tours. Answer: that seems really cut and dry, but it was a misunderstanding. The man got a notice that his license was suspended in 2007, so I guess he assumed he had a license. After all, how can you suspend a license that doesn't exist? He thought that he was allowed to drive. It wasn't until years later that the error was realized. He ended up getting his license shortly after this, and the charges were dismissed, so it works out. Story 37. While shadowing a lawyer on a pro bono case as part of my studies, I sat down with him and his client before the trial, which was about the client allegedly having dealt substances to minors. The lawyer told him 10 times, when you don't have to answer, don't answer. Do not talk about anything regarding dealing substances. When not spoken to directly, do not even think about opening your mouth and saying anything. 10 minutes into the trial, the judge said something along the lines of defendant being accused of dealing substances, and the client just straight up said, yes, I did it, but don't do it anymore. It was a rather short trial after that. Story 38. Not a lawyer, but friend's cousin, who is one, was asked how she could defend obviously guilty people, and she just said it was her job. The main one that comes to mind was a guy that was reported beating another guy with a stick, or something heavier, and she asked the witnesses, so how did you see the accused hold the stick? And they all held up their right hand in an aggressive manner. She then said, but my client is left-handed, and that was enough to get him acquitted. She kind of treated it like a game. Answer: defense lawyers are the quality control for the justice system. They prevent people from getting labeled guilty for being a horrible douche canoe. You have to defend the obviously guilty as vigorously as the probably innocent in order for them to receive a fair trial. Nail in broadcast news. We take the right to a fair trial seriously, and unfortunately, the public no longer receives the education to understand the importance of the word allegedly. I think the change started when civics was removed from high school curriculums and replaced with social studies. Both are equally important. One about your rights and responsibilities as a citizen, and the other to understand that people who don't live like you do are still human beings with all of the rights that entails. Story 39. Now, a few years ago, I was managing an Apple authorized service provider, meaning we were a third-party company authorized by Apple to fix customer computers on Apple's behalf. This was pretty standard in my country, as there were no Apple stores, only retailers. So this lady came up saying we switched her motherboard without her consent and that we erased the serial number, which is technically not possible, as only SN writing was possible in new pieces, at least back in the day. The issue with this computer was a mistake made by the technician where handling the computer, so we purchased a new motherboard from Apple, and the tech, again his fault, forgot to serialize the motherboard. So when the customer checked for the SN, it was empty. We let her know it was a mistake and please bring the computer so we can serialize properly. She refuses, said we will make more mess. Few weeks after, we got a call from the Customer Protection Bureau in my country, and they find nothing wrong with us fixing our issue. Still, the lady was mad and didn't take their suggestion. I thought it was over. Another 2 weeks passed by, and we get a notification from the court about this lady suing us for damages and stealing property. Civil matter. I got the citation papers handed to me and read them before calling the company lawyer. As I'm reading, I noticed they wrongfully write the original serial number in the documents. Let's say that the original was M76XX7D, and her lawyer was suing for the computer N7VW00TD. I notify the lawyer, so we proceed to conciliation process at court. Back and forth questions about the serial number in the court papers, not a single question about the serial number in the service order. After a good 30 minutes of us denying ever having that computer, company lawyers said, well, we will countersue by defamation as this computer has never been in my client's possession, and we will go through Apple system to support that. The lady and the lawyer were furious when obviously the SN never popped up in the searches. Judge dismissed the allegations and they left. I think they never found out that it was their typo, the whole issue. Better thing for the lady would be just accept from us to serialize the motherboard as it was brand new and move on. Instead, she spent not sure how much money in this nonsense. Story 40, not a lawyer, but the defendant victim, whatever. This was when I was still in high school, and things like autism and behavioral disorders in IEPs were still being worked out on. Due to a culmination of many kinds of stress, I had a bit of a meltdown. My IEP stated that what the school was supposed to do was get me to remove myself from the situation, go for a walk and calm down. Instead, what they did was basically grab me, manhandle me, shove me in a windowless staff room, and lock the door behind me. In an effort to try to vent some of that anger, I made an unwise choice to pick up one of those plastic chairs and chuck it at the wall. That was when the school's resource officer, who considered himself an oh-so-important man, rushed into the room, which I was alone in, mind you, and grabbed me from behind. Me being mad out of my gourd and having no clue who's grabbing me, writhed and tried to shake off whoever was grabbing me. The wannabe cop then filed assault charges on me with the intent of wanting to make sure I ended up in juvie. I was suspended from school for over a month leading up to the trial date. When we got there, the judge, who was an awesome woman, basically had this exchange. So, did you all follow anything in his IEP on how to manage that situation? No, but, interrupting the SRO and looking at me, we're going to do what's called a continuance, I think was the word. If you keep your nose clean for 6 months, young man, this never happened. After that, I was moved to a different setting in the school and could do all my work online at my own pace. Thrived. Never had a single issue for the rest of my time there. TL Dutjar bully school cop assaulted young me from behind during an autistic episode, tried to say I was at fault. School is forced to tell the judge they caused the situation by ignoring all of the rules for dealing with me. They agreed to and made every wrong decision. Judge professionally calls them idiots and drops the charge. Answer: that's nuts. My wife is a BCBA. Some schools in PA are like this. She was removed from a school system entirely for reporting school staff to CYS for body checking a nonverbal child into the bleachers where they were injured and needed stitches. The principal and everyone ended up just denying it ever happened, and eventually the parent believed the school telling her the kid tripped. Also, another school, a teacher would call staff to drag a 5-year-old against their will into a safe room nearly daily rather than allow my wife to use alternative ways to de-escalate. And also, school never informed parent of this. I'm pretty sure that is illegal, as that falls under restraint laws. She tried to go against the teacher doing it, and teacher used school union power to get her removed from case. Again, the child's guardian decided not to get an advocate and listen to the school. All because a teacher didn't like this little girl. Girl said she was scared of the teacher and didn't like her to her face. They wouldn't even transfer her to a new teacher. Kid wasn't even disruptive. She would just sit down quietly and refuse to do something. Story 41. I'm not a lawyer, but I've got a story about my parents' divorce. My father lost everything as expected in the late 70s, 80s. He packed what he could fit in his car and left. My mother got everything. House, car, kids. She wanted the divorce. There was no abuse, no cheating. She just wanted out and kept everything, like winning the lottery. My father paid my mother child support and alimony. The alimony lasted right up until my father started getting the alimony checks back from the bank with my mother's new boyfriend's signature on them. Seems she would sign over the alimony checks to her boyfriend to cash. My father took her back to court. The judge basically said, if you're close enough to this man to sign over checks to then you're close enough for him to take care of you and the kids. Alimony terminated. Even my mother's lawyer told her that was a stupid thing to do. Story 42. Let's just say that when my client on the stand said of the plaintiff, I dislike that fudge guy, things definitely took a turn for the worse. Story 43. Not me, but my mom, who represented a school district that was trying to fire a teacher for physically abusing a student, ruled her to the knuckles for misbehaving at IRC. The defense argued that the teacher was from a different generation where that sort of thing was common, and that made it okay for them to ignore the law and abuse kids. When asked for a rebuttal, my mom's team's lead attorney just said, we rest our case. They won and the teacher was fired. Answer. This was my third grade teacher who slapped the backs of my hands with a metal ruler because I had trouble learning cursive. She's old and set in her ways and cursive is important, were apparently sufficient reasons for giving her an exception from our school's absolute ban on physical punishment. The principal intimated that if I told my parents, I'd also get in trouble. So I never told my parents and nothing happened to that teacher. Story 44. Other party was hiding assets, said they couldn't work, and refused to disclose their address. We had an inkling of where they might be. Looked on Google Street View in a rural area, and a Google car just happened to be taking updated photos at the right time and showed them at the address with the hidden assets and undertaking work. You can't opt out of a digital life. Story 45. Now, but I love seeing the lady we hired a lawyer to go up against lose her case. Not because we had receipts, not because we had evidence, not because of the dozens of pages of testimony we'd all submitted, but because this lady couldn't keep her mouth shut, kept interrupting everyone, including the judge, and the more she was told to stop talking, the harder she went. Then I had the true delight and pleasure of seeing a grown man, the judge who looked to be in his mid-50s, pinch his nose, walk himself through some guided breathing exercises. I recognized the breathe in for 4 seconds, hold for 1, then breathe out for 4 technique at one point, and explain the concept of waiting your turn to speak like she was 5 before telling her she'd be held in contempt if she interrupted anyone again. Dealing with that woman bulldozing everyone with her non-stop talking and threats was our entire lives for years, while she literally kidnapped and held hostage the daughter of her ex's youngest child, which was how she was able to abuse the rest of us in so many other ways. We knew she'd take it out on the baby if we didn't let her take it out on us. The years-long power trips were all over in less than 20 minutes because she was so full of herself and had been enabled by her flying monkeys for so long, she couldn't sat you long enough to realize she was digging her own grave. She expected everyone to just go along with it and praise her like they always did Lyle now. Baby girl is back with her parents, connecting with her real family for the first time in her life, happy and thriving, and we all live together across state lines with multiple protective and restraining orders in place while we rebuild our lives. If I'd known this would be the result of our efforts while we were struggling through the abuse, feeling helpless and hopeless, not knowing if when we'd ever get out, I don't care if it would have been 10 times harder. I'd do it all again in a heartbeat. Story 46. I served on a jury once, and the prosecutor thanked the jury as we left the courthouse for not convicting. The defendant would have been a 3-time loser and sent away for an extended stay. Long story short, he was set up by cops in Yonkers, New York. He was accused of robbing some cars and resisting arrest, resulting in one of the officers being on disability for the previous 6 months. He ate some angel dust to hide his substances possession during the arrest, but never broke into a car. He was a big man, about 6'4", 350 lb. His description of the experience of the angel dust working its way through his stomach to his bloodstream while under arrest was hilarious when he took the stand. His defense attorney did a great job showing camera stills from adjoining businesses and argued it was a setup. Photographs proved he never entered a car. It was obviously a target job by the cops who just wanted to bust this guy for anything. I lived a few towns away and knew the reputation of the Yonkers cops. It took me a while, but I won in the jury room that day. Not guilty. BTW, the county never sent me my jury pay. Story 47. Not a lawyer, but work with law firms. Client was 100 in the right and was being sued for a business deal gone wrong. Lawyer asked for every scrap of evidence they have. Multiple times. They get told the client doesn't have some pretty critical paperwork, despite looking everywhere for it. Turns out was in a box in the barn. Client found the box and sat on it for a bit before nonchalantly handing over to the lead attorney. It was too late to submit to the court. Judge denied last-minute entry. Client thought they had until midnight before trial to submit their evidence like it was a last-minute term paper. Clients were in their 60s. The case was lost and they got pissed at the lawyer instead of themselves. Story 48. Friend was a PD. After the prosecutor's closing arguments, she realized they had never identified the defendant as the person who committed the crime. Friend motioned to dismiss and it was granted. Later, she saw the prosecutor crying in the hallway. Answer: in 2017, John Modi was charged with escaping from Hocking Country Correctional Facility, where he was serving a life sentence. Given that he was discovered outside the prison rather than inside it, this seemed like a slam dunk. The prosecution forgot to establish that the venue of the crime, the prison, was actually within the jurisdiction of the court, and the judge was forced to dismiss the case. Story 49. Back in the day, I used to do a lot of 50H hearing coverage work for the NYCMTA. Basically, it's a deposition that occurs before suit is filed as a procedural way for the city to gauge the merit pre-suit. This day, it was a bus accident case, and the person was claiming that they couldn't do anything because of their severe pain all over, specifically in their back. Regretfully, they showed up with their morbidly obese husband and complained before we started about how annoying it was to have to physically fully lift him in and out of his chair every time he needed to get up. I looked at their attorney and I could just see him mentally collapse before my eyes. Story 50. Had a case that already had a no contact order due to other domestic violence charges. He broke the order and violation the girl. He pleaded guilty to breaking the order, contempt of court. Had a judge rule that it was double jeopardy and dismissed our violation case because the DA used the same police report to charge the guy with contempt of court because he pleaded guilty to the contempt charge, which were filed as a separate case. We couldn't use the same police report because they were two separate cases. We always tried contempt separate. I dislike small county. Story 51. Don't know if this story counts, but sit down and spend a while to learn about Calamity Jane. Not a lawyer, but my father told me one of his favorite cases. My dad got a job offer in a small town as assistant district attorney. Spent a few years there until he started working as a defense attorney in a private firm. A little bit later, a partner set a file on his desk. Calamity Jane. Now let's talk about Calamity Jane, a 78-year-old weathered cowgirl. In a town of about 10,000, it is legal for cowgirls to do a cattle drive through Main Street if they absolutely need to. Jane did this every year, albeit very inconvenient to the town, as she was pretty much the only one who did this. Hence the nickname, Calamity Jane. Now, the file my father received was a defense case for attempted takedown. Apparently, a hot air balloon was over Jane's property and spooking her cows. Jane came out shooting a shotgun towards the balloon. According to the plaintiff, he could hear the shots whizzing by. He said she wanted to eliminate him and his friend. The reason why this file landed on my father's desk was because it was a slam dunk. You could not prove she wanted to intentionally eliminate the two individuals in the basket. She came on as a client and said she didn't know them. They were spooking her cows and only fired a shot straight up in the air to scare the guys away. Never pointed it at them. Easy case, but the plaintiff had a friend, the new assistant district attorney. This new assistant DA came from a big city and was only there for the job for a bit, never liked the town, and wanted to jail Calamity for his friend. Next, Calamity Jane met my father for the trial. He informed her that this case will be easy. Jane said this will be easy because she had definitive proof that he is crazy. She provided my father with incomprehensible letters that she typed about the actions of the plaintiff. Every day he would get these letters from Calamity Jane, and they would make no sense. No matter slam dunk case, right? Fast forward, jury picking day. My father was assistant DA for a few years and knew a lot of people around town, especially farmers and ranchers. The new assistant DA couldn't be bothered about that. The new DA would pick metropolitan small town folk, thinking they would dislike Jane for all the cattle runs through Maine Saint, while my father had a fine sample of ranchers in the jury box. Here's the thing. The plaintiff came up on the stand, and his DA buddy asked him all the right questions. But no evidence could say she shot directly at them. My father came to the same conclusion with the plaintiff. She could have just shot off a warning shot up in the air. Slam dunk, right? Again, jurors pretty much consisted of farmers and ranchers, and you could tell they sided with Calamity Jane, even after all her fights in the local bars previously in the past. Finishing up the case, Calamity barged into my father's office, demanding that she testifies on the stand under court of law instead of just a deposition. This is very, very bad for a defendant. You know how you should shut your mouth and ask for a lawyer. You will most likely incriminate yourself under prosecution. After pleading with Calamity, he relented and they went to court. Even the judge told her that she shouldn't get on the stand. Bad idea. They had to move this case to the biggest courtroom in town on Main Street. The place was packed with over 300 people now. Jane came up to give her account on the situation. Under my father's defense, she told the story that the shotgun was just to get the balloon to go away as a warning, just like she said in the deposition. No malicious intent, prosecution time. After some standard questions, the assistant district attorney said, "Calamity, would you say you're an educated woman?" "Yes." "Did you finish high school?" "Yes." "Ever finish college?" "Did you get a degree?" He said, "Yes, I had my degree in biological engineering at USC in 1964. He just realized he messed up his line of questioning. Any education after that?" "Well, I got my master's at Berkeley." Shock in the audience. Assistant DA, snarl key. "Are we to believe that you graduated a top-tier school to take care of cows?" "No. My pa always wanted to get myself an education. I went to a great school, but that wasn't good enough for Papa. I went to Berkeley and then got a great job for a decade or two. Saved a lot of money. But then my pa's health was failing, so I went back home here. He passed, and I've been taking care of his cows ever since." The assistant DA still wanted to provide evidence that, "Thank you for watching the video all the way to the end. If you'd like to see more content like this, you might be interested to know that I've created another channel with a similar theme, especially for those of you who enjoy what I do. I'll leave a link in the description, and I hope to see you there. Take care." Lawyers, what were your "this guy isn't winning" cases? Before we start, don't forget to subscribe to the channel so you don't miss the next videos. I wish you a pleasant viewing experience. Story 1. Had a client tell me she couldn't be charged with tipsy driving because her boyfriend was steering from the passenger seat and she was just working the pedals. Pass that consult on to someone else with no shame. Answer. One of my all-time favorite episodes of Cops back in the day was when a teenager with a permit got pulled over for reckless driving and her father was in the passenger seat tipsy as a skunk. Guy fully admitted he would force his daughter to illegally drive to the bar to pick him up all the time, and he seemed proud of it too. The schadenfreude you felt as you watched his face while the officer explained that all of the crimes were in fact his and not his daughter's was one of the most beautiful things I think you could possibly experience. Story 2. Not a lawyer, but was in court to testify. Defendant in another case is pleading guilty. The judge requires him to allocute, and he gives a detailed description of his crime. He finishes, the judge looks at some paperwork and says, "Sir, that's not what you're charged with." Answer. I'm now wondering if that technically counts as recordable evidence for the prosecutor to use in whatever subsequent charges they might file. I mean, it's technically on the record, but it feels like that's in some legal gray area. Either way, though, I guarantee the prosecutor was writing every word down for later, regardless once they realized that Shoot for Brains was confessing to a completely different crime. Story 3. A friend who is a criminal defense attorney was called at 3-something a.m. by the presiding judge. The sheriff is on his way to arrest your client who is having his bond revoked. I am calling you at 3 a.m. about that because he is having his bond revoked for posting a real name social media threat directed at me and my family. Story 4. I used to work in forensic science and had to testify a lot. One of my coworkers was on his way to testify when he passed by a courtroom that had its door open and heard the attorney screaming at his client, "How can you show up tipsy to a DUI trial?" Answer. This is similar to the case I was